Well, good evening everyone. This is your host Arsh Khan. In this video, I'm going to discuss about the case of Bilkis Bano. Recently, the Honorable Supreme Court of India has set aside the Gujarat government's decision to grant remission to 11 convicts who were involved in the gang rape of Bilkis Bano and the murder of 7 of her family members during the riots in the state of Gujarat. Now, let's quickly discuss the facts of the Bilkis Bano case. What is the background of the Bilkis Bano case? Now, during the 2002 riots, Bilkis Bano, who was a pregnant woman at that point of time, was subjected to brutal gang rape, and 7 of her family members, including her 3-year-old daughter, were mercilessly killed by the mob during the riots. This led to the extensive legal proceedings, and CBI investigated this particular case. In the year 2004, Supreme Court transferred this case from Gujarat to Mumbai after Bilkis Bano faced the severe death threats. And the court directed the central government to appoint the special public prosecutor in this case. Moving further, in the year 2008, Mumbai court delivered a verdict and held 11 individuals guilty of murder and gang rape. And here, the Mumbai court marked a significant and a crucial step towards justice for Bilkis Bano. Well, moving ahead, in the year 2022, in August 2022, Gujarat government granted remission to these 11 convicts that led to their release, and this sparked off the massive controversy regarding the jurisdiction of the Gujarat government, whether the Gujarat government possessed the jurisdiction to grant remission in this case or not. So this was the particular legal issue in this case, whether the Gujarat government possessed the jurisdiction or the authority to grant remission in this case or not. Now let's see what the Supreme Court held in this case. Supreme Court held that the Gujarat government lacked the authority or the jurisdiction to grant remission in this case. Why? Why so? Because if we look at the law of revision, Supreme Court elaborated and explained, interpreted the law pertaining to revision that is given under section 432 of CRPC, which says that state governments, no doubt, state governments do have the power to suspend or remit the sentences. However, court noted that section 7b clearly states that the appropriate government is the one in whose jurisdiction the offender is sentenced. So, court pointed out that the decision to grant remission should operate within the domain of the state where the convicts were sentenced and not where the crime occurred or where they were imprisoned. So that is the law that the court pointed out in this very case. Now moving further, Supreme Court came down heavily on the Gujarat government and even criticized the Gujarat government's approach to unlawfully exercise the power that rightfully and actually belonged to the Maharashtra government in this case, that is to issue the remission orders. Further, Honorable Supreme Court of India eventually rejected the convicts' plea to protect their liberty, and the court directed the convicts to surrender to the jail authorities within the period of 2 weeks. That's all. Thank you very much.